Good morning and welcome to Backchat. I'm Hugh Chiverton. Your co-host today is Rachel Cartland. Rachel, good morning to you.
Morning, Hugh.
On the programme today, we're talking about the extradition bill. The Law Society has urged the government not to rush into introducing new legislation, calling for a comprehensive review of the relevant laws instead, and a bigger role for the SAR's courts in handling requests. John Lee, meanwhile, says that judicial independence is not that bad in the mainland. Chief Executive Carrie Lam has been explaining the rationale of the extradition bill to consuls and dismissed as totally unfounded allegations that she would simply follow the CPG's instructions when handling extradition requests. Well, ahead of the silent march by the legal profession today and the large-scale march on Sunday, how does the legal debate stand? Let us know your thoughts. You can leave a message on our Facebook page, Backchat and RTHK Radio 3. You can email us, backchat@rthk.hk, or call us on 233-88266. That's 233-88266. After 9:20, we're also talking about the issue of social media screening for US visa applicants. Well, joining us today, we have Lawrence Ma, who's a barrister and chairman of the Hong Kong Legal Exchange Foundation, Mark Daly, who's a human rights lawyer and a council member of the Law Society of Hong Kong, and Michael Davis, who's a senior fellow at the Woodrow Wilson International Centre in Washington and a former professor of law at the University of Hong Kong. And after 9 o'clock, Johannes Chan as well will be joining us, a professor in the Faculty of Law at the University of Hong Kong and a barrister. Let's perhaps go to Mark Daly, first of all. Mr. Daly, good morning to you.
Good morning.
So you're a council member of the Law Society in Hong Kong. So you recognise that something's got to change, that there needs to be a review, that this hasn't changed in 22 years, and it's essentially out of date. It can't cope with the modern world.
Well, from my personal view, is in principle, there's nothing wrong with studying the issue and looking at it, and there's a lot of research to do on this. So I don't think one can oppose that we need to look at this. But the thrust of the Law Society paper was that this shouldn't be rushed, and that was the main point, the initial point of the paper. Why are we rushing this? And because there's a lot further research to be done, and so I think that was the main point that was being made by the Law Society paper.
Mr. Daly, is it true that there's something of a split within the Law Society between those who just say shelve the bill, it's so bad, and those who say work on the bill, we can improve it?
Well, I think that's a product of the fact that this has been too rushed. There's a lot of different ideas out there. I wouldn't say there's a split. There's a lot of ideas out there. Certainly in running for council, there was a huge concern. The lawyers that I spoke to, they were opposed to the government rushing this through. So, yeah, there's a number of views. That's normal, and that's why it shouldn't be rushed. We want to do this reasonably.
But do you agree that there is what the government calls a loophole that ought to be rectified?
No, I think I agree with those that say that that's a little bit misleading, saying there's a loophole. It was intentionally not. The agreement was intentionally not made with the mainland. I look at an article by Jerome Cohen. Invite your listeners to look at that. Very good article, quite recently, and the crux of this is that the mainland judicial system is still not up to it, and he says they should engage with the reforms that they said they were going to do a long time ago. Look, I'm a Canadian passport holder. I'm very sensitive to this issue. There's 2 Canadians arbitrarily detained. We don't know the specifics of their charges. They're not entitled to a lawyer. They're exposed to, cruel treatment, and the judiciary is not independent there. So, well, how can we deal with that system?
But John Lee, the Secretary for Security, is saying that China ranks rather high, or comparatively high, on international measures of judicial independence. Is that correct?
Not sure where he's getting those statistics from. I think he's out of step with most people in the world that look at the judicial system in China.
He quoted the World Economic Forum, which is based on basically on executives in particular countries.
Is it sort of opinion survey in effect, or?
Yeah.
I'm not sure. I'll have to look at that one. But the there's another one, the rule of law index, and China is way down the list. I think 82 or 84 or something like that, compared to Hong Kong, which is near the top 10.
Lawrence Ma, good morning to you.
You and Rachel.
Yeah,
morning.
Good to talk to you again, Chairman of the Hong Kong Legal Exchange Foundation. That's a fairly reasonable request, isn't it, given all the complexities? I mean, there's this whole shopping list, to be honest, of issues and technicalities and question marks over aspects of extending the Fugitive Offenders Ordinance to the mainland. Doesn't it make sense to just hold off and take a little bit of time to study these things?
Well, I don't want to talk about time, though. I mean, this is obviously a time which the government has thought is appropriate. But should we go back to the United Nations Model Treaty on Extradition? I mean, the whole purpose of it is to combat crime and drug dealings. Now, in that regard, what the agreement between the countries is that there should be no political offences transfer, and there should be no transfer if there's torture or cruelty. Now, most important is there has to be minimum guarantees of human rights according to the ICCPR. Now, if you look carefully what are the minimum guarantees in ICCPRs are, they are 7 factors. Now, those factors include, for example, to be informed in a language which the person is charged with. Now, if you go back to the criminal procedural law of the mainland China, which is drafted and promulgated in the 1980, and then revised and amended very recently up to 2018, many of these provisions, the 7 guarantees, seven types of minimum guarantees, are listed there. For example, you got the accused was given the charge sheet under Article 187. The accused will be informed of his charge under 187 too, 10 days before the trial. It has to be a trial without delay, and then the law there says that once you're arrested, you have to be prosecuted within 2 months, and then only in complicated matters you can only a 1 month extra is allowed. The accused is given allowed to have legal representation, Article 14. He can retain a lawyer, Article 20.
Okay, what if these are routinely not observed? Then what does the judge, considering a case, how do they stand?
Sorry, I can't hear that.
If in a particular jurisdiction safeguards like that are routinely ignored, then does the judge have to look at the practice? Does the judge have to look at what actually happens, or does it just have to look at what's written down as the safeguards?
Well, I think it is at that stage it would be the prosecution and the court together would monitor the implementation of the criminal procedural law. Then of course, if I may continue, you are given legal aid if you want to, if it is a crime that is punishable by death or life imprisonment, 35. And very recently, they've added the right to examine witnesses by the accused, Article 194. That's a very recent insertion. And you are entitled to an interpreter under 190.
Okay, I think the point would be that's irrelevant, because there are all kinds of things written down in China which don't actually appear in practice. The Constitution of China says that there is a free press, that the people of and there isn't a free press in China.
Yes, you're right.
We all know. So are you supposed to? Is a judge supposed to commission a report into the practice of law in China, or how do they make those kinds of judgments? It's a bit tricky, isn't it?
That concern is well understood. We all worry about it. Some people do, but as a judge, for example, if you are in Hong Kong, if there is a executive decision to extradite someone in Hong Kong back to the mainland, for example, that person goes for judicial review, and then the court looks at whether the executive decision actually infringes the basic law which guarantees human rights, okay? And the court will look into the minimum guarantee to see whether formally there's minimum guarantees provided by the law in the mainland China. If there is, then the court would.
But again, they're looking at the law. They're looking at what's written down. They're not looking at the reality.
Exactly. Yeah. So what happened, if I may quote you the case of Lai Chang-sing, that was in 2007, where Lai Chang-sing was alleging tortures by mainland China if he were to be extradited. Now, what the Canadian federal court said was that if you are tortured, if there is a chance of being tortured, we will not extradite you back. But the problem is the two defendants who are now witness against Mr. Lai, his co-partners, when he were committing the crime, were not tortured. So the evidence of the incriminating evidence were not obtained by the authorities using tortures and other means to extract confessions. So as such, the Canadian court was saying, well, look, you can't show that. Mr. Lai has to prove, at least on the balance of probabilities, that there is some evidence of torture and there was simply none. And as a result, he was extradited back to the mainland China. Of course, the mainland China actually at that time provided an assurance that Mr. Lai would not be sentenced to death or torture, and he's well living and kicking in the mainland now.
But isn't the basic problem the difference really between the spirit and the letter of the law? I mean, many years ago, I did a degree in politics where we studied the Russian constitution at that time. Again, like the Chinese constitution, beautifully written. You look at it, if you came from Mars and looked at it, you think, wow, this is so good. But as we all know, unfortunately, the reality on the ground is quite different. The way in which things are interpreted, the way in which things actually happen. Isn't that what people in Hong Kong are so scared about?
What is important is the minimum guarantee. And if it is a high-profile case that is being well reported and the person is a high-profile criminal, I would have thought that there would be a certain degree of international monitoring of his case back in the mainland, such as Lai Chang-sing's case back in the 2007. So, I mean, international scrutiny and pressure would probably ensure the officials in the mainland would closely
But international scrutiny and having a probability that this would work if it's a high-profile case, that doesn't sound like a legal safeguard. That sounds like a punt.
Gamble. Yeah, punt.
Well, I mean, you cannot be assuming every person and officials in the mainland breaks the law. I mean, there are consequences, and these laws are national laws that has to be implemented. They are cadres. They are party officials. They have sworn a very serious oath. I mean, in many of these cases...
I mean, they have sworn... they're
not political cases,
Well,
right?
I mean, for example, it is a party policy that there is no judicial independence. Xi Jinping has condemned judicial independence.
Well, but there is adjudication independence. There would be means and safeguards against corruptions. And many, look, Hugh, the offences that we would be extraditing back to the mainland, if there were any, would not be political. And the party would not have any interest in it or to exert any influence in it, right? So many of these would be hardcore criminal matters.
But another thing I think that people in Hong Kong are very worried about is this possibility of commercial disputes then somehow being transformed by people cooking the books, and you get back to Hong Kong and you find you're suddenly being picked up and extradited. I mean, I've been quite surprised recently by the number of friends in business who've said to me, oh yes, I know somebody who's in prison in the mainland now as a result of a commercial dispute that took place in China. And isn't that the sort of thing that Hong Kongers think, that this could happen if this amendment goes through?
Well, I mean, mainland has laws against corruptions, and and other things. I mean, we can't speculate on what your friend told you because we don't have the full fact. But when a court is examining a case of extradition of the Hong Kong government, the defense has to show that there is a degree of torture, or there is a possibility of being tortured, or there's evidence that he would be subject to inhumane treatments, or their minimum guarantees of human rights were not given. I mean, you can't run a case on suspicion, can you?
No, but equally, I'm afraid the kind of actual experience is that the guarantees, however good they look on paper, are a bit flimsy in practice.
Well, I mean, as far as I said, I mean, just like Mr. Lai back in 2007, he was speculating that he will be tortured. And the court's decision is that, well, if you say you'll be tortured, show us some evidence that, at least in your case, that's relevant to you, that the witnesses were being tortured, and there was none. And as a result, he was extradited. And the court has to make a decision based on evidence and not some news reports of some Western countries, which says that there would be hearsay evidence of people were being not well treated by, or being told by a friend, for example. So it would be hard. But the most important thing is you come back to these extradition agreements. If you have to subject every extradition country to a maximum human rights standards as like the top tiers in the World Justice Index, I think, you would never get an extradition agreement signed, for example, with third world countries, some of them. Because, and as a result, these fugitives would all commit crimes in the, good rule of law countries, so to say, and flee to third world countries, and he would never got extradited.
Michael Davis is with us, a fellow at the Woodrow Wilson International Centre in Washington. Mr. Davis, good morning to you, and thanks for joining us once again. Do you agree with the Law Society that, I mean, we've got to change this one way or another? The world has changed a lot in the last 22 years, let alone our relations with the mainland. Crime is a lot more international. There's a lot more people travelling around and so on. We've got to sort this out one way or another. We've got to sort out, and it is a glaring, anomaly, let me put it like that there is no extradition between Hong Kong and the mainland. But something's got to be done.
Well, I'm less convinced of that. I think that the one country, two systems model began with the idea that the mainland system really didn't meet the rule of law standards that apply in Hong Kong. And we know this original ordinance, when it was passed, it specifically allows, through a legislative process, ad hoc extradition to everywhere on earth except mainland China. So there was a very clear recognition that the mainland system was not up to standard. And so therefore, on just about any case, the risk that basic rights would be violated by the criminal process on the mainland was recognized from the get-go. And I think the one country, two systems model itself was designed to reassure the world. So if we start collapsing Hong Kong into the mainland system through this back door, then there are more fundamental issues that go beyond just the extradition of a given criminal defendant to raise question about the system itself. And we've seen overseas governments that have been asked to have confidence in the one country, two systems model and treat Hong Kong distinctly have already started raising questions about it. This is why Carrie Lam felt the need to write to members of the U.S. Congress to try to explain, to sell her case. But it's interesting, if you read over that letter that she wrote, in no place does she ever say the mainland system is up to the standards that we would expect. She just goes on and on about how Hong Kong is great, which of course is why Hong Kong would feel threatened by sending defendants to the mainland system. So there is in place already for all the rest of the world except mainland China a way to reach ad hoc agreements. And it is interesting that Hong Kong apparently hasn't worked that hard on reaching other forms of agreement, which you can have an extradition agreement with foreign countries. I think there are about
but Mr. Davis, as you know, other countries have arrangements with the mainland. They can deal with it. Is it because, is your concern because of the nature, because of our relation to the central authorities? Does that affect it?
That's exactly right. I think
if so, why? Because the government will say, but it's in the end, it's down to the courts, and the courts are not beholden to Beijing.
The draft legislation doesn't purport to apply the Hong Kong Bill of Rights in the first instance fully to the case of extradition. That is, the courts are not going to be asked whether the mainland trials and criminal process that the defendant faces match the Hong Kong standards in that regard, so that the legislation doesn't go that far. But there's also a problem that even if it did, the Hong Kong courts would be under enormous pressure because, in effect, judging on the judgment that was actually made years ago when the original legislation was passed, the mainland system isn't up to that standard, and in fact hasn't really changed significantly. Mark Daly pointed out Jerry Cohen's op-ed on this, but Jerry Cohen actually is one of the world's leading experts on China's criminal justice system, even has trained many mainland professors and so on in this area, and he is very skeptical about the mainland system. In some ways, argues that it's gone backwards in some respects because there was an attempt to reform it during the Zhao Ziyang period leading up to 1989, but that was all reversed after 1989.
All right.
So the mainland system just isn't up to standard.
All right, Lawrence Marr. Let's hear from Lawrence Marr. Yeah, go on, Lawrence Marr.
Sorry. Well, I mean, you look into. Sorry.
Carry on. Yeah.
Yeah, sorry. I mean, you can't look at whether you can't ask the Hong Kong government to write in the ICCPR standard into our extradition treaty because it's already there. It's already when we're extraditing someone from Hong Kong to the mainland, there has to be minimum human rights guarantee, and we look to the other side to see whether that minimum guarantee is provided. If that minimum guarantee is provided, then the treaty would require us to extradite that person to that country. I understand what Jerome Cohen's article has said. I'm not sure whether it would be an academic discussion or it was actually a case study of every cases in the mainland. I mean, I can't comment on it. But I mean, as I said, I mean, the law is the law, and it has been there, and officials have. I've seen them observing the law, and we've spoken to them when we visit China, and there were serious consequences of them breaking it, not observing the criminal procedural law.
Michael Davis.
I once was asked to give a seminar to mainland prosecutors in Beijing, about 200 of them, and it was one of the interesting observations that almost unanimous. They said that they do not. I was lecturing on human rights, that they don't meet human rights standards. They all agreed. They, in fact, kind of chuckled about it, that these standards exist and they simply don't meet them. And this is, I think, the general consensus that the Chinese criminal justice system, which often uses a kind of dossier to compile a prosecution of a defendant, and in spite of whatever law reforms have been made, usually doesn't give a defendant full right to cross-examine all witnesses, and so on. All of this, the process simply doesn't meet the standard. So if this is thrown to a Hong Kong court to judge it, probably every judge would conclude that it doesn't meet the standard, but there's a lot of pressure then on the courts because they, in effect, have to judge that the mainland system isn't up to standard. And then we're told, well, but the chief executive will guard to make sure the standards are met. But we have no evidence that our current chief executive ever says no to the mainland government on any kinds of pressures that have been put on Hong Kong. So I think the public lack of confidence is very easy to understand.
Lawrence Marr, do you want to say anything?
No,
okay.
I can't comment further.
All right. Well, we're going to take a break now for the news at 9 o'clock and continue after that in a few minutes' time. We're also going to be joined by Johannes Chan, Professor in the Faculty of Law at the University of Hong Kong. If you want to comment, then please just drop us an email, backchat@rthk.hk. Tom has sent an email with the subject line, John Lee Lying Slaves. My instruction is, please try to sing this nursery rhyme dedicated to John Lee called The Lying Slave. John Lee, yes, Grandpa, telling truth, no, Grandpa, telling lies, yes, Grandpa, open your mouth, ah. I'm not singing that for anything. Thank you very much indeed for that, Tom. What do you think? Drop us a line. The forecast now before the news at 9. Sunny periods and isolated showers. Very hot during the day. Temperatures up to 33 degrees. And there's a very hot weather warning now. 30 degrees, humidity 82%.
Political conditions didn't currently exist in France for a 50-50 merger with the French company. Analysts say factors which complicated the deal include Renault's current alliance with Nissan. You're listening to the news on RTHK.
Welcome back. This is Backchat on a Thursday morning. It's the last one before the planned march on Sunday against the revision of the Fugitive Offenders Ordinance, which the government say they want to push through next week. And also there's a silent march planned by members of the legal profession. This comes also after the Law Society has urged the government not to rush into introducing new legislation, although reportedly it's only a minority view that they should shelve it. Joining us for discussion, we have with us Lawrence Ma, who's a barrister and chairman of the Hong Kong Legal Exchange Foundation, Mark Daly, a human rights lawyer and a council member of the Law Society, and we're also joined now by Johannes Chan, who's a barrister and professor in the Faculty of Law at the University of Hong Kong. Later we're going to be talking about the issue of social media screening for people wanting to get visas to travel to the United States. If you've got any thoughts on that or on the extradition bill, then do email us, backchat@rthk.hk, or comment on our Facebook page. That's Backchat on RTHK Radio 3. Matthew, we'll get to your comment maybe a little bit later and look at other comments there. Let's perhaps go to Johannes Chan now. Good morning to you, Professor Chan.
Hi, good morning.
And thanks for joining us. You've expressed, I know, concerns about a number of aspects of the proposed revised bill, or the bill as in its applicability to the mainland. What are the main ones? What are your main concerns when it comes to the extradition bill?
Well, I think at the core of it is still people lack confidence about the mainland legal systems, and in particular whether someone who has been extradited back to China would receive a fair trial. So, notwithstanding that the government has now proposed a number of measures, it didn't address or allay the concern of the people in Hong Kong whether someone would receive a fair trial when they are back to China. And among all the measures, we see that most of the measures indeed were to be included in a future executive agreement, and with no details at this point. And whether the government could secure those guarantees depends very much on the bargaining power of the chief executive, depends on whether the other side is willing to accept it, depends on whether those terms would eventually be altered, and so on. And given the rather asymmetrical relationship between the chief executive and the mainland China, it is difficult to be confident or comfortable with an executive agreement to be negotiated in future as the protection for human rights guarantee.
Do you think, Professor Chan, that the bill is salvageable, or do you think it's so bad we should just say, sorry, put it on the shelf for another 22 years?
Well, I think this is a matter which we should continue to discuss, but one there is no urgency, as we have seen all the talks about Taiwan murder is nothing more than a smoke screen. There is no way at the moment as it stands that Taiwan is going to accept the bill. So if there's no urgency, I think the matter needs to be thoroughly discussed. And I would not say that it will shelve it forever, but how many times we have seen a bill which is opposed by both branches of the professions, concerns expressed by the business sector and many other foreign countries. So not to say that a large number of people go to the street to express their concern. So it certainly needs a lot more discussions. And if the crux of the bill, of the crux of the problem is that people lack confidence, let's try to strengthen people's confidence at what China has done in improving their legal system, rather than to rush through the bill at this stage.
You say you've listed all these various people who've got worries about the bill, but the fact of the matter is, isn't it, that there's apparently been very large numbers of people ready to sign up in support. The discipline services within the government have said they support it. Carrie Lam is coming out and saying that there are various people who thought they opposed it but are now willing to accept it. It's not so clear-cut that the community is against this, is it?
Precisely because it is not clear-cut, and precisely because there, on both sides there are a lot of different views which have been expressed, all the more that it should not be rushed through. It simply shows that how controversial the bill is.
We've been hearing from Professor Davis about a seminar that he undertook in Beijing, I think, with prosecuting lawyers in China, where they apparently admitted more or less that the way that the laws administered in China is not up to what we would expect to be the case. Do you have the same impression of what's going on in China? And what's the feeling of the legal profession there? Would they like to see reform, or do they think the system they've got is really the best one?
I think there are, if you look among the legal professions in China, indeed there are a lot of dissatisfaction about the existing systems, and certainly they are looking for reforms. I think, to be fair, by and large, in the last 40 years, China has gone a long way, emerging from a situation of complete lawlessness to present day, that at least in most areas there are laws which govern the situation. The main problem in China is twofold. One is a lot of these laws are on paper, and when it comes to enforcement, it is a completely different thing. There are numerous occasions where legal provisions in the law are not observed. And the second problem is that the judiciary is not independent. Even the Chief Justice of the People's Supreme Court admits that independence of the judiciary has no place in China legal system. It is a Western product. And if we look at the criminal trial, and in particular in criminal trial, almost all the serious major criminal trial ends up in convictions. And it is here where law and order and social ideology, where courts are expected to cooperate with the state, which results in almost a very exceptionally high percentage of conviction, and which is worrying. And there are a long list of cases where due process has not been observed. If one goes to the record everywhere, and they are not just political crimes, it is all kinds of crimes. Where legal representations were not given, confession was extorted, and even if we look at how China responds to the extradition proceedings in Canada of the senior executives of Huawei, and what's wrong with all of a sudden, how many people believe that the former diplomat of Canada has really committed any crime, but except it's a retaliation. And this is how criminal law is used, and that happens very recently.
Lawrence Moore, what about that question, the second concern that Johannes Chan expressed there, apart from the sort of kind of theory and practice thing? The fact that there isn't judicial independence, and they will boast of the lack of judicial independence. Judicial independence is framed as a Western trick by the Supreme Court and by Xi Jinping, who's written on this.
Yeah, well, I mean that's a political statement in a sense that when they were talking about
well, it's a statement by the leader of the. It's a statement.
I understand.
Yeah.
Yes, it is. That's
Are you calling him a liar?
No, don't put words in my mouth, Hugh. What they're speaking is in the context that there's no separation of powers, and as a result, there should be no judicial independence. But don't forget, it has always been the case there has been adjudication independence in the mainland, where they have mechanisms to safeguard, for example, inter-level government intervention. For example, a city's court would not be influenced by the same level city's government because of in the old days before the reform, the city's government was responsible to provide fundings and equipments and facilities to the courts. Now in these days, the reform has been that the city's judiciaries supply and funding would be provided by by an upper level government, for example, up to a province. So the province would provide materials and fundings to a local or a city court. So as such, they have been doing reforms so as to fan away influences from fellow officials. Now, whether you call it satisfactory, I'm not sure. But what Michael, Professor Davis, has just commented was what he was requiring was the highest standard of guarantees of human rights, as like in Hong Kong and other top tiers Western democracies. What the UN treaty was requiring was a minimum guarantee of human rights under the ICCPR. Now, if we are talking about maximum guarantees, we'll go nowhere. Because, as I said, all the criminals fled to the third world countries would not be extradited.
But in Hong Kong, maybe it's a luxury, but should justice be a luxury? We are used to a very fair legal system, a very humane overall prison system. Shouldn't we be entitled to expect that on the mainland too?
Oh, of course, we would expect, but the world's not perfect. I mean, you can't expect every country and third world countries in this world would be able to live up to the standard of developed Western democracies as such. That's why the UN treaties requires a minimum guarantee from these third world countries, so that if they provide a minimum guarantee, I said again, a minimum guarantee of human rights, then extradition can be done.
Okay, so some emails I'd like to share. First of all, one from Gary, who says, "Hi, Backchat. It's interesting that Mr. John Lee thinks that China's judicial, that's the Secretary of Security's, China's judicial system is getting better. I honestly wonder where he's getting his information from. China's Chief Justice, Zhou Chang, made his thoughts on judicial independence very clear in January 2017, that China's courts must firmly resist Western concepts of judicial independence. Authorities there had said that China requires a legal system which is in keeping with socialism with Chinese characteristics, where reforms strengthen rather than weaken party leadership. The courts in China were clear on the matter too, when they said that creating a legal system independent of the party clearly violates the constitution, and that trial and prosecution authorities are all subservient to the NPC. Mr. Lee's arguments, or shallow attempts to convince the people in Hong Kong on this court, hold absolutely no water." Marcus says, "If this is such an urgent matter for the unelected government in Beijing and Hong Kong, why is it not for Macau?" Bowen says, "Dear Backchat, I agree with the Law Society's submission on the proposed amendments to the law on fugitives, but would suggest that in paragraph 30, in the section captioned Concerns on Extradition to Mainland China, on top of the two undertakings by the requesting state or party suggested by the Law Society, consideration should be given to further adding undertakings covering some of the protections mentioned in Article 14 of the ICCPR, especially as China has signed but not ratified it. These should include, for example, the relevant person's right to a fair and public hearing by a competent, independent and impartial tribunal established by law, right to be presumed innocent until proved guilty, and right not to be compelled to testify against himself or confess guilt. The government maintains that the guarantee of a fair trial and other safeguards will not be written into the bill itself, and Theresa Cheng has said that would give the government flexibility in case-by-case negotiations with requesting jurisdictions. But the undertaking suggested to be given by requesting jurisdictions could be precisely about those rights, which are so fundamental that there shouldn't be any flexibility or room for flexibility about them in negotiations. The so-called non-exhaustive list of safeguards that the government could draw from, referred to by Theresa Cheng, could also be seen as an uncertain or ill-defined list of safeguards from another angle. As pointed out by Hugh and Rachel, some states do not in reality provide for protection of rights guaranteed by its laws. The idea of writing in any undertaking is that the government will need to follow up on the undertaking and use compliance records as a ground for considering future requests from the same jurisdiction. As for Lawrence Ma's citation of the minimum guarantees in criminal proceedings in the ICCPR, referenced in the Model Treaty on Extradition of the UN, it's highly likely that China will accede to its incorporation into... it's highly unlikely that China will accede to its incorporation into any surrender agreement with Hong Kong, as she still hasn't ratified the ICCPR. Those observations from Bowen. Mark Daly, when it comes to trust, there's an argument that it's not black and white. You don't completely trust everything that happens in the mainland, or you completely distrust and think that everyone's constantly lying. What you do is you build in safeguards, and you build in various layers, to make the best of the job, to make a workable solution. Isn't that what the administration has been trying to do feverishly over the past few weeks, to listen to these concerns and to apply remedies where applicable? But the basic, thrust of it has to go ahead.
No, I think there's a longer-term amount of work that has to be done to if you do any deal, if you're doing a business deal, you do your due diligence. And I think before we make a deal to extradite somebody to the mainland, we need to know far more, expose more how the system works on the mainland, what the reality is as opposed to being on paper, and there needs to be a lot of work done there. Research-wise, the Lai Chong-sing example is brought up, but I think we need to find out more about what the deal was to send him back, what were the circumstances surrounding that, what were the assurances, what is the position on that. We don't send somebody back as a guinea pig to a system where we have all these concerns, and particularly when China is fond of using parental motherland talk, and Hong Kong's the child. What are the chances that the child is going to say no to the parents? And I think the Reuters article recently about the concerns of the judges being put on the firing line to say no to the mainland system in this context. I think there's too many concerns. We have to study this in much more depth before we go ahead.
All right, quite a few emails, some fairly long, but just a couple. TC on Facebook says, so let's review the original rationale for the legislative amendment. 1, justice for the young Hong Kong woman killed in Taiwan. The ROC Justice Department has stated that it won't proceed under the current arrangement. 2, to prevent Hong Kong from becoming a safe haven for criminals. By removing various sex crimes from a list of extraditable offences, Hong Kong will become a safe haven for sex offenders. By trying to close one loophole, the government is creating more loopholes. I remember Alan Zeman on Backchat last week stating his support of the legislative amendment on those reasons. I'd love to know what he thinks now. Furthermore, in regards to exempting sex crimes, where are the various feminist and child welfare groups? Their silence is deafening. And Johannes Chan, I'd like to hear your reaction to a point raised by Matthew in an email, which I'll have to edit for length. Matthew points out that there was a speech last month by Vice Premier Han Zheng on the bill. He did say he's the member of the Politburo Standing Committee. He said that there were 4 categories of people who could be extradited from Hong Kong to mainland China under the proposed amendments. This is the reports anyway. And one of those was Hong Kong residents who commit crimes against national security in Hong Kong. So that if you were a resident of Hong Kong and you committed a crime against national security in Hong Kong, you could be extradited from Hong Kong to mainland China under these changes to the law. That hasn't really elicited a lot of discussion. What are your thoughts on that, Johannes Chan?
Well, on the one hand, of course, this is one of the main concerns of people from Hong Kong, and national security is something pretty ambiguous in China. Of course, the extradition bill said that political crime will be exempted. The difficulty with a lot of national security crime are public order crime. And that's precisely the sort of things that Hong Kong are worried. And it is also precisely in this area we have seen a lot of people who are allegedly charged with national security crime. They are not given any fair trial. They are not given any due representations. The latest, Wang Quanzhang, he is also convicted of national security crime. So imprisonment incommunicado for more than 3 years, no access by parents, by families, no lawyers, representations, and then got another 5 years trial in a closed door that is not open to the public. So that's the sort of justice that we have, and precisely this is the sort of areas that we are extremely concerned.
And what would be the basis of that? Because we're talking there about people who commit crimes against national security in Hong Kong, so they would be breaking mainland laws, basically. So if you broke a mainland law in Hong Kong, you could be extradited. Is that the understanding?
Or if you advocated Hong Kong independence?
No, I think this refers to people who are breaking the law in the mainland. But then, of course, at the moment, it has to be a crime both in Hong Kong and in China. So in that sense, China, we are not talking about, although China's law could apply extraterritorially, but at the moment we are talking about breaching national security law in China. But some of the crimes,
the quote is again breaking national security laws in Hong Kong. Hong Kong residents who commit crimes against national security in Hong Kong.
Right. Now, it depends on the context, again, and a lot of computer crimes and even conspiracy affecting the financial system in China could be a matter of national security already. So the national security is so broad, and so that, and it is possible to find a crime. It's not difficult to find a crime which broadly fall within national security or public order and anything. Disclosing the speech of the national leader before that was published is already a crime for national security. And the further worry, of course, is in the pipeline we have seen the pressure of China on Hong Kong to enact Article 23 law as well. So that would give an extra hands to catch people in Hong Kong simply for doing things that China does not like.
Okay, well, Johannes Chen, thanks for joining us. We are out of time. Quite a few other emails as well. We will return to the topic on Monday with Danny Gittings, and there will be the march on Sunday in the meantime, so a chance for further discussion. Before the bill goes to LegCo, Elliot, for example, says this is not just about extradition for political offences or human rights. This is about a real fear people have of the fundamental structure of the mainland legal system. And Nigel says there is no judicial independence where the judiciary is subject to political legal committees. No judicial independence at provincial level either, on your last speaker's own admission. Nigel and everyone else, thank you very much indeed. We're speaking there to Johannes Chan from the University of Hong Kong, Professor in Law, to Mark Daly, from who's a human rights lawyer and a member of the Law Society, and Lawrence Ma, Barrister and Chairman of the Hong Kong